So before we get started, wanted to say a big thank you to Siegfried and Rivera's team for helping put this together, Stephanie, as well as Ashley Artiles from our team, helping put this webinar together regarding annual meetings and elections. For those of you managers, you're getting right at the deadline to renew your license. We did want to let you know that Siegfried is providing a credit for this course today. If you haven't done so yet, please email either Stephanie or Ashley your CAM number, and we'll make sure to get you the necessary certificate. The emails will be provided right at the end of the webinar. If not, it's the same email where you received the webinar link to be able to log in. So with further ado, I wanted to go ahead and get this webinar started. I know a lot of people are anxious with regards to elections and everything that we have going on. Everything that we have going on with COVID and so forth. So first, I wanted to make sure, Robbie, are you able to see my screen there clearly, the sharing of the presentation?
Well, I don't see the presentation at the moment, but I do see your screen.
Okay, let me go ahead and put up the presentation really quick. This must have stopped sharing. Oh, I shared the wrong thing. Sorry about that.
So in the meantime, I wanted to also express my appreciation, Rafael, to Affinity and for you guys setting this up and for the opportunity to present this material, which I think is appropriate in light of, and timely, frankly, in light of the season in which we are in right now. There are a good amount of our clients that are getting ready to send out their first notices for the Condo Association annual meetings and elections. And we've sent out a good amount of them already because most of them have their annual meetings and elections toward the end of the year. And so this is a very timely presentation. And of course, for those that are familiar with how the process works in the past or has worked in the past, it's also particularly interesting because as with everything else in the year 2020, our current pandemic state of mind has, provided us with a few curveballs as to how annual meetings and elections are taking place. So, we do think it's somewhat interesting, even for the individual that may consider themselves an expert in annual meetings and elections historically.
Yeah, things have definitely changed. So allow me to introduce at least you, Robert. I want to give you at least a formal introduction so everyone can get to know who you are. Robert Blanche has been a member of the firm Siegfried and Rivera since 2001 and concentrates his practice in community association law. He represents condominiums and homeowners associations throughout Florida, handling a broad range of legal issues pertaining to the operation and management of community associations. Robert Blanche has handled all aspects of community association law, including but not limited to covenant enforcement, interpretation of governing documents, vendor contract negotiation, and drafting, amending governing documents, preparing and attending board meetings and membership meetings, election and recalls, collection, fair housing issues, and insurance claims. He also assists associations with that have issues with turnover or throughout the turnover process, guiding them on the hiring of experts and representing them in construction defect claims. Mr. Blanche is also a board certified specialist in condominium and plan development law by the Florida Bar. He's a member of Southeast Florida chapter of the Community Association Institute and previously served as the board of director. He's also a member of Dade County Bar Association, Cuban American Bar Association, and of the Real Property Probate and Trust Law section of the Florida Bar. Mr. Blanche is currently a member of the St. Thomas University Law School Board of Advisors and serves on the board of directors of Matter Academy, a nonprofit organization which oversees the operation of 26 charter schools in Miami-Dade County. Mr. Blanche also previously served as a member of the board of directors for the Spanish American League Against Discrimination. He speaks regularly at state-approved board member certification courses and educational seminars pertaining to the establishment and operation of condominium and homeowners associations in Florida, and authors articles pertaining to various issues affecting community associations. So thank you so much, Robbie, for being here with us today. With regards to myself, I am co-founder and CEO of Affinity Management Services, We are a community association management company which manages efficiently and effectively with dedication and passion. We enjoy taking care of our people and, most importantly, bringing value to our clients. Our organization has the privilege of serving over 8,000 units in the Tri-County area. So I guess enough about us, Robbie. Let's get into the gist of the webinar. So I guess, Rob, if you can go over a little bit about the condominiums and the HOA and a little bit difference of how they're established.
Yeah, for those that have actually participated in some of our prior presentations, a lot of this information might seem familiar. And frankly, what happens is that condominium and homeowner associations generally get there and derive their powers and their existence from Florida statutes. And the chapter that is dedicated to the condominium concept is Chapter 718 Florida statutes. And for homeowner associations, you're looking at Chapter 720. You also, for both organizations, condominium and homeowner associations, we also pay a good amount of attention to chapters 617 and 607, and respectively, it's the Not-for-Profit Corporations Act and the regular For-Profit Corporation Act. In addition to the documents and chapters that I referenced, we also tend to pay a good amount of attention to what is called the Florida Administrative Code, and mainly for condominiums, though there are some sections that address and affect how homeowner associations operate. And last but not least, it's always important to be mindful of what the association's governing documents provide. And when I refer to governing documents, and I may use that throughout this presentation, I'm referring typically to the declaration of condominium. If you're dealing with a condominium, if you're dealing with a homeowner associations, it's usually the covenants or the declaration of restrictive covenants. In HOAs, it usually takes on any number of names. Nonetheless, it's the declaration for condos and homeowner associations, bylaws, articles, and we could throw in there potentially the rules and regulations as well, though rules and regulations don't really have that authoritative of relevance. So we deal, and we have to be mindful of that whenever we're addressing what associations can and cannot do, what the obligations are, and what associations need to do with regard to meetings of the members, annual meetings, and elections, etc. And that takes us to who can attend these meetings, right? And so, as the current slide indicates, in condominium associations, all of these meetings, and we want to be careful about addressing both meetings of the members and meetings of the board of directors. And that's why this first slide is there to address the concept of a board meeting. And a board meeting is a meeting where you have a quorum of directors present to conduct association business. And the reason we want to be aware of this is because most of what gets done in condominium and homeowner associations gets done by the board and must take place at board meetings. And following your annual meeting and your election, you generally have a board meeting, which we refer to as the organizational meeting, and that is the meeting at which the directors, the newly elected directors, or the directors that hold over, will elect or appoint their officers, president, vice president, secretary, treasurer. But these board meetings are generally open to all owners or all members of the association. They are, any owner or member of the association has a right to speak and to address the board on any item that's on the agenda. With regard to these meetings, they must properly be noticed, right? And so with the exception of some special types of meetings, for instance, your budget adoption meeting, the meeting of a board of directors to adopt a special assessment or to amend certain types of rules, you need to have a 48-hour notice. Those other meetings, as the slide indicates, require a 14-day notice requirement. And of course, with regard to these meetings, and particularly those we'll call them special board meetings that require the longer period of notice, we have this concept called a proof of notice affidavit, right? Proof by affidavit, and that is simply stated an affidavit that needs to be included or provided by whomever sent out the notice on behalf of the association, attesting to the fact that the notice was sent out in accordance with the association's governing documents, as well as the applicable procedures or provisions of the statutes. And of course, as things, and we've all been accustomed to nowadays, and how the trend was moving, owners have the option to consent to receive these notices electronically. Now, there are two things, and we will address this later on in the presentation, and that is the concept of electronic voting. So owners could opt in if a board of directors establishes into electronic voting, but that is not to be confused with the ability of an owner to consent to receive notices by means of electronic notice. And boards could also pay attention to that. It shouldn't be presumed that notices can be sent out by email necessarily. There are procedures or processes to apply. And in the next slide, we get into the concept of homeowner association, or rather, we'll continue condos. We'll get into the HOA's meetings momentarily. But okay, so this is a good slide to identify the distinctions or the differences between board and unit owner meetings, right? We refer to unit owner meetings synonymously as members meetings. And so here you notice that your default notice, right? And your default notice requirement is for 14 days. That's from the statute. Now, of course, your governing documents might require a different type of notice. It may require notice be given 30 days in advance, 21 days in advance. So this is a good point to illustrate the need to familiarize yourself not only with the statute, but also with the provisions of your governing documents, because both are relevant in what gets done. Now, if you have a set of governing documents that provides that members' meetings can take place with 5 days notice, you still need to be mindful of the statutory 14-day notice requirement. So that is something that needs to be carefully analyzed every time a meeting is going to be properly noticed. And of course, this is relevant because if you don't properly notice a meeting, then whatever action you take at that meeting is subject to challenge.
Of course.
Right? Because, go ahead.
Now, I wanted to ask you, because now, obviously, in the midst of COVID and a lot of meetings in certain associations, especially 2 or 3 months ago, I still hear it now. What's your take on having these board meetings on Zoom or these kinds of platforms, and the way that they should be noticed, so at least you're in somewhat of a compliance? What's your take on that? What's your opinion?
Well, that's actually a great point that you raise, Rafael, and I know that one of our listeners also submitted a question prior to the presentation on the concept of elections and meetings via Zoom or these electronic platforms, right? Or virtual platforms, however you want to refer to them. And it's a good point because on the one hand, when we started off in this current environment that we're in right now, back in March, I remember, nobody really knew how long this was going to last. Here we are now in September, and I think I've been to my office maybe a couple times since March, and I've been working out of the house and doing more Zoom and WebEx meetings than I care to admit on a daily basis. But in condos and in homeowner associations, the advent of these platforms has been very helpful, and has also proven that societally we are at a point in which these technologies are embraced, and at least I have noticed that they have assisted or served to increase participation, increase awareness, and increase the flexibility of an association to conduct business. Now, with that in mind, the Florida statutes that we referenced earlier have not kept up with the pace of technology, right? And so, for instance, for board of directors meetings, it has always been recognized that the board could meet and conduct meetings by teleconference or by phone conference. And of course, when these types of platforms like Zoom and the other types of virtual meeting platforms came about, we association lawyers started equating and drawing comparisons between the right of a board to meet by teleconference into these types of platforms. And so, of course, so long as you have the board attending by way of and have a device that has a speakerphone, that the individuals that choose to attend at the physical location of the meeting can listen in on what the board is saying, and so that the board can also listen to what those individuals are saying. So long as you've got that capability, you can conduct board meetings by teleconference. So it is entirely possible to have a board meeting and none of your board members present in the room, and they could be there on a screen, on a computer screen, the way we are speaking right now. And that meeting could be a legitimate, real, effective meeting at which you can have votes of the board and you can actually transact business. Now, you do, however, still need to have a physical location for the meeting.
Okay.
So there needs to be a notice of the meeting, as we discussed earlier. It needs to be an agenda. The notice needs to be posted somewhere, on the property, and it needs to identify that this meeting is physically taking place somewhere. And at that somewhere, you need to have a speakerphone, and in this case, the computer screen, so that if an owner chooses to show up, they can speak and hear and watch all of this taking place. You can't avoid, the statutes have not given us the ability to avoid that attendance or that need for a physical location. Now,
Okay.
of course, we are balancing that with today's world in which, whether it's the National Health Administration or the Centers for Disease Control or whoever's making up the rules nowadays, we still need to be mindful and observe these social distancing guidelines and the fact that people don't want to be out of the house, or that you may not have the workforce or the personnel to get a room ready, right, for these meetings and to set up the room. And so we have to deal and wrestle with these things. But if there is a board meeting and you don't have this physical location, even if nobody's showing up to that physical location, the question that there is no answer to right now is the meeting effective? Is the meeting proper? And frankly, that hasn't been challenged, and there is nothing in law that suggests that you can do away with the need for a physical location. Now, with that in mind, I do want to say that there is this concept called the emergency powers, and both condos and homeowner associations legally and according to the statutes have the right to declare and assume emergency powers. And as a condition to exercise and declare emergency powers in a community association, you need to have a declared state of emergency, whether it be by the county or by the state, by the governor, but there needs to be a declared state of emergency. And apparently we are in a declared state of emergency. The governor and the mayors have all declared states of emergency. And those orders, those declarations of a state of emergency have continued, okay? And so when this whole when lawyers such as myself, these community association lawyers, first realized that there was this declaration of a state of emergency, we're used to seeing those declarations of a state of emergency with what we always deal with, right? Hurricanes. And, we've got like 4 of them now spinning out there, but, every time we would have a hurricane, declare state of emergency. And so these emergency powers that you read in the statute are typical and seem to suggest and seem to apply to those types of emergencies, right? You need to repair your building. You need to dry out your building. You need to get access to and from your building. And so everybody started saying, oh, great, we got to declare state of emergency. So emergency powers automatically apply. Condos and HOAs can adopt emergency powers. And then other lawyers started saying, wait, not so fast. you know, these emergency powers are to address, quote, damage to the property.
Correct.
And we're here dealing with an infectious disease. We're dealing with a pandemic of a virus where this is not causing damage to the property. And so, of course, lawyers started getting creative and saying, well, of course, there is damage to the property, you know, and maybe the infestation of the virus at the property is, quote, some type of damage. And so lawyers start getting creative, and lawyers start saying, you know, absolutely, the state of the emergency powers extend to these types of declared states of emergencies. And then you had the state of Florida's Department of Business and Professional Regulations, right, which has the DBPR, which has the Division of Condominiums within it. They jumped in and they said, the emergency powers in the statutes do apply to this type of an emergency, but they only apply to this power and that power and the other power.
Correct.
And of course, you know, lawyers like myself start debating, you know, because we have nothing better going on. We start debating with each other whether or not the Division of Condominium or the DBPR even has the authority to come in and opine on whether or not, you know, the state emergency powers and their applicability, and whether or not they should extend to this situation. And so then they came out and said, oh, okay, you know, now you could do away with our interpretation or whatever we said earlier about the state of emergency. And so now we all kind of like scratch our heads and say, well, do the emergency powers apply to now or not? This lawyer, me, the one you're talking to right now, I do feel that there's a better likelihood than not. There's a better likelihood than to the contrary, that the ability for a condominium and a homeowner association to avail themselves of the emergency powers in the statutes, I do feel that it applies to this declared state of emergency. Now, again, I cannot predict the future. I'm not a judge. I don't know what a judge would ever rule on this issue. And so, of course, I could be wrong. It won't be the first time, but I do feel that there's a better likelihood than not that the emergency powers do apply. The relevance of this whole long-winded discussion about emergency powers is that when you look at the emergency powers, one of the powers allows us as board members, right, allows the board members to hold off on required meetings, right? So let's assume we needed to have an annual meeting, but because of this state of emergency, we cannot have our annual meeting. And so because of that, then the declared state of emergency and the adoption by the association of the emergency powers, and it does require that the association's board adopt or establish the emergency powers. But once you do that, then one of the things you could do definitely is postpone or reschedule necessary meetings. Another thing you could do is take some action without meetings. And I wouldn't suggest that you could do all of these things necessarily, but I think you need to be judicious in how you do it. And so that takes us back to this main concept. In this state of emergency, can you do away with the requirement for a physical location of a meeting? I don't believe so. I think it is feasible for a speakerphone, even if it's just ceremoniously, right, or ceremonially to comply with the statute and put it in a table in an empty room. You know, I do feel we should go through the motions to do that, to at least check that box off and make sure we complied with that legal requirement. And drawing a comparison, I think the same thing should apply to an election and a meeting of the association members, which statutorily also requires that there be a physical location. Okay, and let's be mindful of the fact that while most of us, and all ages included, right, from our youngest of kids that are doing real live instruction or virtual education at homes and at their desks and are learning via Zoom and other platforms. And of course, you've got the Miami-Dade School Board and the school district and the public schools. That was a disaster of an experience that they had with the K-12 platform. And to those that are even more sophisticated, that have done a better job of providing technology and education. And so from our youngest of citizens to our oldest and most seasoned and experienced of citizens, everybody has embraced this technology.
Correct.
But there are still some people that can't,
Correct.
or don't,
Or don't
and
want
have
them.
been unable to,
Yeah.
right? And or don't want to, right? And so
Yeah.
now the question becomes, how do we address or facilitate their right to participate in the process, right? Can we force people to attend via Zoom? And my answer to that is no. I can't force somebody to attend by Zoom, but I can provide them options to call in. I can provide them options to use Zoom. I can make or try to make the physical location of the meeting available within the confines of social distancing, if possible, right? So, we can establish procedures like maybe a registration process, maybe an advanced call-in, and we can encourage everybody to attend by Zoom, as many people as possible, but maybe we may have 2 or 3 or 4 or 5 people that must attend in person.
Yeah.
And so shouldn't we be able to accommodate them if we have reasonable and safe means by which to do so? And that's why we need to start looking at these things on a case-by-case basis, because we don't want to disenfranchise people that want to be and have a right to be part of the process.
Correct.
And one thing we need to keep in mind is that these are uncharted waters. So we need to try to be as reasonable and as practical as possible, balancing the environment in which we're in today, preserving safe attendance and participation at the meeting, but also trying to ensure the traditional, as much as possible, the traditional notions of attendance and participation at meetings. And if we can strike a balance, and I think we've done that at many properties, if we can strike a balance, then I think that would be the advisable approach, rather than just saying, with a blanket statement, we could do things on Zoom,
Correct.
entirely. And I don't agree with that. I think we cannot exclusively say that because of the pandemic, we could do things on Zoom.
Of course.
Okay. Without providing a physical location. I think we need to try to provide a physical location and need to make every reasonable effort to do so. And before mandating Zoom as your only means of participation, I would even suggest you consider postponing the meeting. You get what I'm saying? So I think these are conversations that all board members should be having with management, with their lawyers, and with the professionals, with the board. And we need to, really start balancing what is to be gained and what potential pitfalls we may encounter because of this.
Of course. No, I mean, listen, you mentioned a lot of great points, Robbie. I mean, it's like everything else in life, right? You have the people that abuse these emergency powers and are taking advantage and not being transparent with their associations and really notifying them of what's going on. Because the way we see it is if you could host the meeting, right? And if you have a website similar to what everyone else is doing, is posting those meetings on the website, making them available. For those that don't know, if you do use Zoom, there's also the call-in option as well. I agree with your point that there has been much more participation even in board meetings, because in most cases, unless there's some mini revolution going on or some political issue going on within the community, most of the times the meetings are fairly small in size. You're not getting a ton of people attending. However, we've kind of seen the opposite when we're sharing these Zoom links, sharing the telephone numbers, that we're getting much more participation. It could be two things, right? People are tired of being tied up and they want to do something different because they're home. But I believe that this is the future. The future, hopefully there's going to be legislation now in the coming year that'll clarify some of these points so that we can make sure that we're conducting ourselves in the way that we need to conduct ourselves. Because ultimately, if we can get more participation in the meetings, while some board members may not want that, at least you're getting better feedback of what's going on. It's much more efficient as well. You don't have to drive anywhere. You don't have to go anywhere. If you're an investor, you're able just to pop in, listen to what's going on, and then pop right out and do what you need to do. So I'm really hopeful that in the coming years that there'll be some legislation that'll clarify some of these points, so that'll make it easier both on attorneys as well as management as well as board of directors.
Absolutely.
So with that said, I have here with the condo election. So now most associations, not all, because really it's dependent on your documents, are falling within this election point within the year. So if you can
Right.
give Robbie a little bit of what are the protocols in order to follow those elections properly, at least we can start maybe with the condos.
Sure, of course. And I also want to mention, Rafael, that we've got these slides, and I know we're trying to balance. And we don't just want to read from these slides, of
Yeah,
course. So whoever is in the audience and would like this presentation, they could reach out to any one of us or to Stephanie or Ashley and get this information and have it for their records. But we'll go through these slides quickly to also provide us with an opportunity to address some of the questions that I
the
know are coming
Q&As.
in on the chat from
Definitely.
our attendees. And so real quick, in order to have an election in a condo, there are notice requirements, and condos are a lot more, I would say, technical with regard to the election process in comparison to homeowner associations, right? In condos, we have like a two-notice system. We have the first notice and the second notice. And the first notice needs to go out at least 60 days, no less than 60 days before the date of the meeting. And that first notice is simply an invitation to anybody who wants to be a candidate to run for election to the board. So let's assume we've got a board of 5 board members, and all 5 of them, the term for all 5 board members is going to expire at the next election. So we know we're going to have 5 spots to fill. And we send out this first notice at 60 days before the election. And in response to that, we are expecting to receive candidate application forms, right? An interested
Mhm.
candidate is going to submit a form and say, hey, I want to run for the board, right?
Yeah.
And so that deadline, the deadline for them to submit that form is 40 days before the election. So no less than 40 days before the election, they have to submit that form. And then they have an extra 5 days to submit their resume or their information sheet. And then, of course, the condo has 14 days before the election to send out the second notice. And what is included in the second notice is the agenda, the notice, if there's an election, a ballot, the inside envelope for the ballot, the outside envelope for the ballot, and then, of course, some condos send out voting certificates and proxies.
Of course. So I want to ask you a couple questions here, and I do have a question from the audience as well that we can address now that ties into this. So with the candidate information sheet, right, there's deadlines to that, and the statute says, I believe it's an 8.5 by 11 piece of paper, one-sided. We've had the situation being in South Florida, right, where they want to write in English one side and in Spanish on the other side. Or we've had the situation where someone takes advantage and just writes a ton of negative stuff about the current board or the people that they're running against. Could you give a little bit of insight as to what a manager or a board, a self-managed property, how they should handle those kinds of situations?
Yeah, and that's easy. And the reason it's easy is because the statute gives you no choice but to do what the statute says. And
Yeah.
so as a manager, as a lawyer, for us, those are great situations because we get to say, you know what, don't shoot the messenger. We
Yep.
didn't invent this rule. The people you elected and are up in Tallahassee created this law and this rule. And so you got to deal with it. And the answer to your point is the candidate information sheet or what other people call the resume
Yeah.
could be no more. The limit is one side of a sheet of paper that is 8.5 inches by 11 inches. That's it. So a letter size paper. And legally on that paper, they could put whatever they want. They could say whatever they want. They could put it in whatever language they want. And no matter how you feel about censoring and freedom of speech or whatever you need as a condo, you can't do anything to modify that statement or to not send it out. You must send it out with the second notice of election. You can't modify it. Okay, no matter what atrocities are said in there, no matter what pictures are included, you need to send it out. Now, fortunately, the legislators threw you a bone, right? They basically said, yeah, while you got to send it out, you association, you board members you can't be liable for anything that is included in those papers and those resumes and those information sheets. And so what I tell my client is, listen, you got no choice but to send it, but don't worry about it. Let it go out. Because there's nothing that's going to happen to you if that goes out. Oh, but they're saying all these bad things about us. I'm like, oh, well,
Yeah. Correct. That's it.
sticks and stones can break your bones, but words will never hurt you. Right. I mean, so But anyway, you got to deal with it, and that's what the law requires, and we've got no choice but to deal with it. And that's there are rare instances as a lawyer where you can give like a yes or no answer, or you could give a definitive answer or a black and white answer. And
how is it?
those,
How is it? It depends. It depends.
yeah, usually it depends, and of course you get frustrated that I give that answer, but in some instances, when a lawyer tells you yes you can do it or no you can't do it, then you should be happy that you got a yes or a no answer.
Correct. Of course. Of course.
Now going back to the slide, we got two remaining points on this slide, which is the ballot and the qualifications, and of course we discussed what goes out with your second notice, and I said, if there's an election. Well, the reason I said if there's an election is because in my example, I told you there's 5 spots on the board. If you get candidate application forms from 5 or less individuals, then you don't need to have an election, right? Because who else is going to get elected? But if you have candidate application forms from 6 or more people in this hypothetical that we're discussing, then you do need to have an election. And of course, in your second notice, we're going to have to send out the ballot. And we're going to have to send out the ballot envelopes. And in condos, you need to send out an inner ballot envelope and an outer ballot envelope. And the purpose of the inner envelope is to preserve the anonymity, the anonymous vote, and the secret vote, right? And that's why the inner ballot envelope is usually referred to as the secret ballot envelope. And then the outer ballot envelope, you put the inner envelope inside of the outer envelope. And the outer envelope, the purpose of that is so that when you and I receive that outer envelope, we know who voted for this unit, right? Correct. Unit 504, John Smith is the owner of Unit 504. So it says John Smith. It's got John's signature, right? The law requires that John sign the outside of that envelope and that he put his unit number, his address. And we use that, of course, to verify that John Smith voted. Now, of course, if we get 2 envelopes for Unit 504, we got a problem, Houston. If we only get 1 envelope and it corresponds with the roster and it appears to look legitimate, then we make the judgment call, we accept it, we take it, we validate it as a validly cast envelope, right? And then, of course, when the election starts, we are legally required to open up all of the outer ballot envelopes first, separate the inside envelopes and the outside envelopes. And now, once we're done with that process, now what we're left with is a huge stack of inner envelopes. And by law, I can't tell an owner that he needs to put anything on that inner secret ballot envelope. The purpose of that is so that you and I can't determine who cast that envelope, who submitted that envelope. That's how we preserve the secret vote, because inside of that secret envelope is the ballot. And so by law, I'm forced to open up all of the outer envelopes first. Then I have to open up all of the inner envelopes. And then I get ballots and I tabulate the results of the votes on the ballots. And that's why I cannot require or include any markings or information on the inner envelope or in the ballot that allow me to determine how a particular unit owner voted. Now, that doesn't mean that the owner can't, let the cat out of the bag, right? The owner could mark the ballot. The owner could say, I am John Smith, and this is how I'm voting because I hate all of the other candidates. I mean, they could do that, but you can't make them do it, and you can't ask them to do it, and you can't prepare the documents in a way that you could identify how they voted. And of course, in order to have the election, we need to make sure that we have a minimum of 20% validly cast ballots, right? So if we have a 100 unit condo and we received, by example, 20 ballots, okay, but 10 of them voted for 7 candidates when they only should have voted for 5, then we fell short of our validly cast ballot threshold because we needed to have a minimum of 20% validly cast ballots. And so, of course, I just gave you one example of the things we look at, but we also look at a bunch of other stuff. Did the proper owner vote? Is a voting certificate required or not for the unit? If a voting certificate is required, did the voting member, i.e. the person identified on the voting certificate as the eligible voter for that unit, did that person sign the outer ballot envelope? Was there a signature or not in the outer ballot envelope as required by law? Did the envelope identify who the unit is or to which unit that ballot applies? we need all of these elements by law in order to certify that we have a valid election. And once we do determine that there is a valid election and we've identified all of these thresholds have been met, then we count the votes and we elect the directors by plurality. Plurality means they don't need a majority of the vote, because in the example that I gave you, in condo A that has 100 units and we received 20 or 25 ballots with 5 vacancies on the board, but maybe 7 candidates. If there may be a point where no one particular candidate received a majority of the votes cast.
Right.
But we could count and see if candidate number 1 received the most votes, then candidate number 2 received the second place votes, and that is what we call a plurality. Okay. So we're covering a lot of ground here, and we're going over all of these issues. Now, the qualifications of a board member, you know, definitely to be a candidate, you can't be delinquent on any monetary obligations owed to the association.
Now, I want to address that point with you, Robbie, if I can, because in order for them, it's my understanding that in order for them that there has to be a vote casted, that you're basically waiving their votes as to vote. Isn't that correct? You have to have a board meeting beforehand.
Well, there's two things going on. You could, if you're looking at it from the point of view of who is qualified to vote,
yes,
as a voter, the board of directors could suspend voting rights. Okay, but they're not automatically suspended. And the statute says you could suspend voting rights for an owner who is delinquent in monetary obligations to the association. And I believe the threshold is 90 days. And so that is in the statute, and the board needs to take action to suspend voting rights. Correct. If the board has not taken action to suspend voting rights, then you cannot presume that a particular member of the association has lost the right to vote by virtue of the delinquency they have in their monetary obligations to the association. Now, that goes to the ability of a voter to vote, right?
Okay.
There's also the eligibility of an individual to be a candidate for the board, right? So yes. We go backwards in time to the 40-day deadline, right? That deadline when somebody had the right to submit their candidate application form. If you receive a candidate application form from a particular owner and you see that that owner owes any monetary obligation to the association, it could be as little as 1 cent, okay? If there is any monetary obligation owed to the association, then that owner is not eligible, as of the 40-day deadline, is not eligible to be on the ballot. No ifs, ands, or buts. You cannot include them on the ballot. Okay. And the Division of Condominium and the courts have not created any exceptions to that rule. And so we have no choice but to strictly construe that rule. However harsh it may seem, however unfair it may seem, however draconian it may seem, we have no choice but to preclude a candidate from being listed on the ballot if on the 40-day deadline they owe any monetary obligation to the association. Okay. So if you want to be a candidate for the board, okay, you better make sure that you don't owe anything to the association on that 40-day deadline. Correct. All right. Now, obviously, there are other eligibility requirements which are listed on the slide, like, you know, you can't be a convicted felon whose voting rights haven't been restored. And so, you know, there's other things that you must be 18 years of age or older. You know, we'll go through the list, but those are the more relevant issues. Now, we talked about vacancies on the board previously, and generally speaking, once you're on the board, going back to our example, that 5-person board, if there's a resignation or some other type of event that creates a vacancy on the board, that director could have sat on the board for a whole year, right? But maybe he resigned, or maybe he passed away, or maybe something else happened that now there's a vacancy on the board. And so what happens? Well, so long as whatever caused that vacancy wasn't a recall, okay, then the remaining board members have a right to fill that spot for the unexpired term of that individual, right? So if there were 6 months left in that director's term, then the remaining board members can fill that vacancy for those remaining 6 months, right?
Okay.
And that's what we call, that's what we refer to as the unexpired term. This also takes us to a very interesting point that has developed, I would say, relatively recently. And relatively recently, as you could tell from the slide, we go back to 2018. You know, there was a legislative session in 2018, which created a law in Chapter 718 that said, if you are a candidate and you have served 4 consecutive 2-year terms, or 4 consecutive or 8 consecutive years on the board, you are no longer eligible to be on the board, right? So if you've continuously served for 8 years on the board, you can't be reelected to the board. It's basically a term limit. Of course, the exception to that is if 2/3 of your unit owners voted for that candidate, right? So notice, I can't prevent that individual from being included on the ballot.
Correct.
I can't prevent them from being included on the ballot, but I need to let them run for election, because if they get a vote of 2/3 of the voting interest, then they can be elected to the board, right? That's basically the legislature's way of saying, wow, people really want them to be on the board if 2/3 of the people voted for them to be on the board. The other exception is if no other candidate submits their candidacy, right? Then and you do, even if you've served more than 8 years, you can be on the board. Now, why 2018? And this is relevant because when this law came out, there were a lot of board members that were already on boards for more than 8 years.
Yep.
Right.
Yep.
And so people were kind of like debating, well, so and so can't serve on the board anymore, because he's served more than 8 years previously. And we were all kind of like scratching our heads, and we were having to make judgment calls as lawyers, and we were saying, well, maybe the 8 years, maybe that clock for the 8 years shouldn't start ticking until the election that starts after July 1st of 2018, because
Correct.
That's when the law became effective,
Which
right?
is like
And
most
before
laws,
that,
right?
right. And before that, the law wasn't effective, and therefore, we should start counting that 8 years. And then other people kind of like disagreed with that, and fortunately, we started getting some arbitration cases that, gave us some guidance. And of course, now I believe the collective school of thought is that the 8 years starts running as of the amendment of those statutes. So
Gotcha.
as of July of 2018 is when the 8 years starts. And then, of course, we can start getting into some other creative arguments. What if the board member resigned, right, and got off the board, a month before the election,
for a day or for 2 days,
right, or for a day.
Correct.
Now when you read the statute, you come up with these arguments that, well, given the wording of the statute, they may not have served continuously for 8 years before their upcoming election. And so, is that sufficient to overcome what appears, or what some might argue is the intention of the statute? And so it's very interesting. I don't think we need to really bog ourselves down on this issue, but there are and have been some discussion amongst the lawyers and others that practice condominium law on whether or not there could be some workaround of the statute. But we won't get into that now. I guess that's for board elections and annual meetings 2.0.
Yeah, that'll be a whole nother webinar, by the
Yeah. So this also, we talk about the certification on this slide, right? Of course, when you are elected as a board member in a condo or an HOA, the law requires that you do one of two things. You can either sign what is called a certification form, which is kind of like basically an acknowledgement that you're familiar with all the laws and rules and your governing documents, and you basically know what you're doing and nobody needs to teach you anything. Or you could do what is called a board certification course, a board member certification course. And if you do that and you sit through the board certification course, which is typically around 2 hours, maybe a little more, maybe a little less, but I think the law requires that it be a couple hours. You get this certification, you get a certificate,
Correct.
and you need to turn that into the association. It needs to be kept with the secretary of the association. And the law requires that the secretary of the association maintain that as part of the association records, either for 5 years or however long that person is on the board without interruption. So that person might be on the board now for up to 8 years without interruption. And so for either 5 years or 8 years or however long that person's on the board, you need to keep that as part of your records. And once you as a board member take that certification course or sign your certificate, that certificate is good for however long you sit on that board without interruption. So the moment you resign or are failed to be elected or are recalled, then if you get back on the board at some time in the future, you need to either submit a certification form again or take a certification course again.
Okay. Okay. So you go through that entire process, right? And then all of a sudden someone wants to kick you off the board. So can you tell a little bit about how the recall process works in the condos?
Yeah, I mean, the recall process, both for condos and HOAs, is, I'd like to say it's simple. It really isn't, but I guess we have to try to simplify it. Otherwise, we might be here for hours, if not days. So what the statute provides, and it's a pretty fair or equitable concept, and that is, whoever elects you has a right to take you off the board, right? And so if the people that elect you can remove you for any reason, for no reason whatsoever, or for whatever reason they want, and what they would have to do is either petition to have a meeting of the members scheduled, right? And at that meeting, a majority of the owners in the condo will have to vote to remove you. So
Okay.
if you're talking about a 100-unit condo, at least 51 owners would have to vote to remove you.
Mm-hmm.
Or alternatively, they can do it by what is called written agreement. Now, it's not like a contract with 100 signature lines. No, that's not how it's done. There is a form that is provided by the Division of Condominium, and you can get it online. And it's like a 3-part form. It's got Part A, Part B, Part C. And you need to be, the voter, the owner, need to be able to check off which directors you want to remove, which directors you want to retain. If you're removing a majority or more of the board members by recall, then you as the group of owners voting for recall can also select who you choose to replace those board members. Right. And then Part C identifies you as the voter, right? You need to put your name, you need to put your unit number, you need to print your name, your signature, the date in which you submitted the document. And then all of these agreements get served on the association. So they get put together by a class representative, right? There's a representative of the owners, voting for recall, and that person compiles all these agreements, all these documents. And then when they feel they have enough, they turn them into the association. Whether they give it to the manager, the lawyer, the registered agent, the board members, they serve it upon the association. And then as of that service, as of the time that those documents are delivered, then the association has 5 business days within which to schedule a board meeting. The board must decide whether or not the recall is facially valid or not. If they determine that it is facially valid, then the recall is effective immediately. Mm-hmm. If they determine that it is not, then they've got 5 business days within which to file a petition for arbitration with the Division of Condominium. The Division of Condominium is basically going to rule on whether or not the recall was facially valid or not. And once the Division of Condominium issues its order, then the recall could be valid.
Okay, excellent.
So that's a recall.
So I know with HOAs, and we're cutting a little short on time. I want to make sure we get to some of these questions. I know things are a little bit different. So if you can, what I'll go into is if you could go a little bit over the HOA board meetings, or would you think we should go into kind of the election straight into it since we're running a little bit short?
Yeah, I mean, for the most part, and you can go to the next slide. For the most part, HOA board meetings run the same way as condo board meetings. Right. So we'll kind of there are some nuances, and that's why I recommend people to get the slides so that they can see what the differences are. But they're very subtle, very negligible. When you look at HOA elections, that's where you do see a big difference,
Big
right? So
difference.
an HOA members meeting is going to be similar to a condos members meeting, but an HOA's election is going to be very different than a condos election. An HOA has the right, if they want to make their elections as complicated as condo elections can be. But typically speaking, they're not. And typically speaking, HOAs are designed to move a lot more flexibly, a lot more smooth. For instance, at an HOA meeting, you generally could have candidates nominated from the floor, which means at the meeting, a candidate could be nominated. And so you may not have a ballot in advance of an HOA meeting.
Correct.
You don't have this 20% requirement for an HOA meeting. In condos, you cannot vote by proxy. In an HOA, you could, unless the documents provide otherwise. In a condo, you have to vote by the ballot, right? The two envelope system, the ballot, and all of that. In an HOA, you can't. And so, well, unless the HOA's documents or the procedures have been established to have that process. And so there are those nuances between the HOA's election and the condos election. In a condo, you need 20% minimum ballots or validly cast ballots to have an election. In an HOA, that's not the case, because it's not relevant whether you've achieved validly cast ballots, but rather what you need to have for an HOA election to take place is that you need to have a quorum of a quorum of members present at the meeting at which the election is taking place. And once you've achieved that quorum, then the election could take place. So those are, in a nutshell, the nuances and the discrepancies between the condo and the HOA. There's no 60-day notice requirement for an HOA election. There's no 40-day time period to submit candidate forms. And those are the nuances. And last, this is, I believe, our last slide, and that is electronic voting. And we got into it briefly, but if a board wants to do electronic voting, whether it's for a condo or an HOA, I highly recommend you reach out to your lawyer to do it. Yeah. Meaning to establish it. Correct. Because it is a very complicated process for the layperson to get into it. And the law doesn't require that you hire some outside vendor to do it, but I would highly recommend that you hire some outside vendor to do it. And I would highly recommend that the outside vendor know what they're doing. So the first part of the process is that the board of directors needs to establish electronic voting, meaning they need to have a board meeting, 14-day notice for that board meeting. At the board meeting, they need to adopt a resolution establishing a deadline to submit notices to the owners to opt into electronic voting. You cannot force owners to vote or participate in electronic voting. You can only provide them the option. An owner who opts in must also have the option to opt out of electronic voting. If an owner opts into electronic voting, that doesn't mean that they can't vote in person or by traditional methods if they wanted to. If you're going to do electronic voting, you need to have a system, right? The electronic voting system must meet certain thresholds, certain parameters, certain requirements, certain criteria that the statutes require and impose. And so because of that, and because of all of these nuances and tedious technicalities, I would highly recommend that if a board wants to establish electronic voting, you do so with the help and guidance of your community association lawyer and manager. I personally like electronic voting. I think it's a great system. I think it increases voter participation. I think it's generally user-friendly. I think that it could be used not only for elections, but also for other types of votes that associations generally might want to get, whether it's amendment of condo documents, use of reserve funds for other purposes, you name it. It could be very helpful. Some boards don't want there to be elections, and so maybe they don't want to have electronic voting installed, right, or approved. And so these are the issues you want to discuss with your lawyers and your managers if it's something you are considering doing. And so with that said, I don't know if you want to go through some of the questions real quick, and if we can't get to all of the questions, maybe we could submit some responses, but let's see what we can do.
Sure, most definitely. So the first question I have here is from Michael Den. He says he lives in a condo association and he says that his the material that gets sent is always sent late. Um, and he wants to know, like, are there any specific forms? So can they produce their own envelopes, or can they produce their own ballots?
Um, unless there are formally and properly adopted procedures to the contrary, the answer is yes. You could print your own ballot. You could print your own envelopes. The problem, however, is you want to make sure that you're doing it properly.
Correct.
And that by virtue of doing it, you're not, creating a situation where that ballot or that envelope is going to result in an invalidated ballot envelope. Unfortunately, with the mail system the way it is,
correct,
the earliest you could send out your second notice for a condo election is 34 days before the election. That's the earliest. And I think it's impractical to assume that's ever going to happen, because you get your resumes on the 35th day. And if you get them on the 35th day, then you got to prepare the ballot and all those
correct,
documents. So even though the earliest you can get it out is the 34th day before the election, generally speaking, I would say that ballpark 30 days is probably reasonable. And the latest you could send it out is 14 days. So you've got this sweet spot of, I would say, 34 to 14 days before the election, right? That 20-day period within which to get your notices out. And our experience, unfortunately, and as of late, is that with the mail system the way it is, 14 days before the annual meeting and election in a condo and even in an HOA might give you some problems. A lot of your owners might not get the documents in time.
of course.
You're still complying with the law as an
Correct.
association. You're still complying with the law, but it may not be enough time for members to get the packages. And even if you get it out 34, 35 days before the election, some associations have encountered problems, unfortunately.
Yeah, of course. You have to keep in mind that, let's say the person that can't drop off the vote, they're going to need to mail it back to whatever address gets placed there. And then there's that delay, which again gives you more reason of why we should be considering the electronic voting option, which honestly, it will be the future eventually. There's always going to be the option of the mail-in, just like we have when we're doing our regular voting for our country. But I do want to point out, at least what we do from a management side, is that we do try to have our stuff stamped with the date before we send it. So if we're sending it out to get printed, we're sending it 2 or 3 days. So at least it's post-dated with the 14 days before or 18 days being that gap that Robert mentioned. So that's an important point to keep in mind as well, because if they bring that envelope to you and it has the wrong post date, the way we see it is you could be looking at some issues there. I have another question here, Robbie. It says, I'm a board member for a co-op. Could you point out any special legislation that affects these separate from condos? And I'm assuming it's with regards to the election.
No, I mean, the statute for the co-op, again, is very, very similar. While the election procedures for condos and HOAs are very different, the election procedures for condos and co-ops are almost identical. And the reason I say almost identical is because the only difference you might find is that in co-ops, you may have fractional voting, or voting that is determined based upon the number of shares you own. And so that becomes one of the nuances. But other than that, the parameters or the procedures or the provisions applicable to elections by condos or election of condo directors is very similar in co-ops.
Correct. And I have
co-ops, by the way, is chapter 719 Florida statutes.
Correct.
719.
I have a great question here from Lisa. Lisa asked if an association had to postpone their meeting, let's say in March, but it was postponed due to the situation with COVID, and it happened in July. Does that mean that the term next year will go July, or are they only having a term from July through March, which was the original annual meeting date or election date?
Well, that would be a document specific question. That's a question, the answer to which would depend on what the governing documents provide, because I have reviewed some governing documents that don't reference anything about when annual meetings need to be held.
Okay.
On the other hand, I've read and reviewed governing documents that require annual meetings to be on a specific date or within a specific month, or no later than 13 months from the last annual meeting and election. So you need to look at that to determine, because for instance, if you had an annual meeting and election in July, you might be able to accelerate your next one to next year's March, right? But you may not, you may not be able to go past July or too far past July, or you might have to get back on track when the state of emergency is lifted. So you really need to be mindful of what your governing documents provide. In the absence of your governing documents providing any guidance, then you could either keep it next July, you can make it next August, you can make it next June, you can make it next May. That would generally depend, because what the law does require is that you have that you call an annual meeting, and
Correct.
that you have an election or call for an election during your annual meeting.
Okay, excellent. And I'm going to take one more here. Let me see. I have here a question with regards to power of attorney. Can a power of attorney be used as a proxy? I'm assuming they're saying in an HOA, because proxies are not permitted in condos.
The answer to that question is no. You cannot use a power of attorney to substitute for a proxy. You might be able to use a power of attorney, for instance, to say so-and-so is authorized to attend a meeting on my behalf and speak on my behalf, but it is not a substitute for a proxy. And so you've got to be mindful of that. What governs here is the provisions of the governing documents as to eligibility. And even recently, we had a situation in a condo where an owner gave, by virtue of a power of attorney, the right to his tenant to vote on their behalf. Okay. Unfortunately, the Condo Act doesn't allow that, and it says that the ballot can only be cast by the eligible voter, by the owner of the unit, and so it didn't allow. There was no room to allow, and there is support, precedential support, precedent case law to support that position as well.
Okay, excellent. And then this is the last question. Does the 8-year rule apply to the homeowners association?
I would have to confirm that. Give me 1 second. I may be able to get that answer in a second.
I think it's only for condo. If
your recollection serves you correctly. Let's see here real quick. I might tend to agree with you. But if we can give an answer real quick
and
now,
while you have that, we have a small icebreaker. Someone loves your art, by the way.
Oh, thank you very much. Thank you very much. Let's see here, statutes. I'll make this really quick if we can.
In the meantime, I guess I'll just jump in. I mean, now I've noticed right now with our clients, a lot of the HOAs are wanting to postpone the elections and hold off just because of the quorum requirements that they have. I know what we're doing is we're making a strong effort to try to push as many clients as possible onto the online platform. There's many benefits outside of just the elections itself. It's also the amendment of the documents. Also for HOAs, if you're over 30 years, you have MIRTA, so the Marketable Irrevocable Trust Act, that you have to recertify. By having the electronic voting set up, it's going to make things much easier for you. So the same goes for condos, but I know with a lot of the HOAs, they're having the challenge of meeting the social distancing guidelines because clubhouses are either too small and they won't be able to meet those guidelines. So if you haven't entertained the electronic voting option yet, I strongly urge you do it. There's a lot of techniques that you could use to be able to get people to opt in by doing surveys or whatnot. But it's a great option for all communities, and it's going to make things much easier for you moving forward if you need to make any changes with your documents.
Yeah, I'm not seeing anything in 720 to mirror what is in the condos, and so
okay,
I would tell you right now, if I find it, which I don't believe it's there, I will send it. If you can get Rafael the name and contact of the individual that asked that question,
sure.
and provide it to me so that I could look at this just to make sure that there's nothing. But my gut feeling is no.
Okay.
My recollection is no, and what I've found right now is no.
Okay. Okay, here it is. All right. Excellent. So, Robbie, do you have any closing remarks? Or I wanted to respect your time and respect our participants' time. Any
Sure.
closing remarks?
No, look, I appreciate once again the opportunity, and I also appreciate all of the questions we've received and the participation by those who have attended this presentation. Um, we can't emphasize enough the importance of observing all of the rules and provisions, not only contained within the governing documents, but also in the Florida statutes and administrative rules regarding the elections and annual meetings for condo associations, as well as homeowner associations and co-ops. They do appear to be some of the most litigated issues in our experience in condos. For some reason, people really want to be board members in condos and homeowner associations. And so, and of course, the monkey wrench that has been thrown into almost everybody's lives right now is the impact that this pandemic has had. And there has been no shortage of how or ways in which it has affected condominium living, which has extended and applied to the annual meetings and elections. And so the advent of electronic voting and Zoom and other platforms such as that for virtual participation at meetings has facilitated things. And I agree with you, Rafael, the legislature is expected to work on, some solutions to this, as well as clarifications and fine tuning on the emergency powers, because, it's like with everything in life, they become reactionary, they work on things like this. And so, board members, managers, lawyers practicing in this field, unit owners should be mindful of that, pay attention to the developments and the nuances, ask the right questions, take these types of webinars or seminars, and have no fear to reach out to qualified, capable, and experienced management such as you guys and lawyers such as our firm whenever there's a doubt, confusion, or question on any one of these issues.
Excellent. Thank you, Robbie. I wanted to thank you and your team again for really participating and making this possible. The information that you guys provide is always excellent. I do want to apologize to the participants that we weren't able to get to all the questions. I do believe that the slides will be sent to if anyone requested. As Robbie said, we're going through a difficult time at this moment. However, if you rely on strong partners, they should be able to guide you. Don't hesitate to call your partners during these times, because the last thing you want to do is, make a wrong decision and impact you down the line and costing you much more. Thank you all for attending. Again, thank you to Stephanie and Ashley for helping put this webinar together. And I look forward to doing another one with you and your firm again, Robbie.
Absolutely. Thank you, guys. Have a great one.
Have a great one. Bye-bye.
Bye-bye.